everybody. Hi, Ava. Hi, good girl. Are you here for your blue buffalo treats? Yeah, I haven't gotten around to moving them into another container. But I'm only going to give you one of these because I spy a box with a very particular blue buffalo on it. I can't imagine who this is from. I am stumped. Wolf lore lover. And I only know that because I got this package too. And I got this far and I recognized the box. Whoops. I thought it was my pants I ordered. They also came. Thank you. Oh, throwing around the scissors. Cat distribution system had some jokes today. Everybody on the Discord after the movie got to see. I opened the door because I was going to show everybody my ramp. And in starts waltzing a kitty. And I'm like looking at it from the top view. And I'm following it with my phone because it just walked right in my house and straight up to Earl and did a nose boop with Earl. And I'm like, wait, are you tiny? You're not tiny. Wait, tiny kitten. You're not tiny kitten. Snitch. And then I'm running after her, going, snitch, snitch, get over here. So Snitch went in that kennel at first. And he yelled, and he yelled, and he yelled. I'm telling him. And I was going to leave him in that kennel despite all the yowling. But then he peed. And I was reminded why I don't have unneutered male cats. He smells like an old Tom. I don't like old Tom smell. But I put him out because he kept yowling, so I put him outside. And then, wouldn't you know it, the very next time I went to let Ava out, he ran right back in my house. We're getting a storm. We've already got about an inch. So I guess he's no dummy. But I now have Snitch in my house. It's okay, Methany. I already told him. Calm down. Methany, you gotta get straight anyways. We gotta get you hung back up. Oh, salmon protein bites. Duck, her favorite. I swear her favorite was the duck. And turkey. And box. You want your duck? No, you're so pretty. I'm calling the vet on Monday. I talked to a gal that works at the pound, the one that gave me the tour that I still have to edit and get posted. I talked to her tonight, and she recommended another vet in town. I kind of want the PAWFURM all going to the same vet, and the one that she recommended it doesn't take large dogs. I've called it before to have it like do Ava's toenails, and when Ava needed to get spayed, and they said absolutely not, we can't do large dogs. And I don't really want them being split up between two vets, one for cats, one for dogs. So I'll call my regular vet Monday. If they don't have the availability, or if they want to charge me $1,000, then I'm going to call the other vet. I'm working on it. I'm working on it. You go, baby. You gotta come out here. Yeah. No begging from under the desk. So I got another Hickory Farms box. And I'm so excited because it comes with Dijon mustard, my favorite one. Or not Dijon. Stone ground. It's my favorite one because, like, I like the seeds. I like the texture of the seeds. And I like the vinegar taste. And it's hard to find it. It's hard to find this Belgian ale. I tried even looking online specifically for this. Couldn't find it. But I love this so much. How to win a Wisconsin girl's heart. 101. Oh my gosh, thank you so much. The second I saw that pattern on the side of the box, I was like, this is not pants. And then the pants that I did buy, I got too big. The pants, I bought the pants too big. Not that I got too big. I did get too big, but the pants I bought were too big. Oh, and then I bought these for Ava. The Best Bully marrow bones that I used to give her, that I have on order again. Yes, I ordered them, even though I swore I was never going to get them for her again. I did. These are, well, I would tell you exactly what they are, but this is how they packaged it. So it just says it's a beef pizzle, braided bully 4-pack, 6 inches. But its ingredients, I wish I was making it up. Hold on. Which way do I go? I go this way? No. There it is. Right there. Beef pizzle. I've never had a pizzle in all of my life. I can promise y'all that. I don't even know what a pizzle is. Maybe I have. Hi, Tiny. Is that your daddy in the kennel back there? Is that your daddy? Yeah. He looks like a rough old lifer. He really does. And you know how you get to be a lifer in them places. You gotta snitch. And then tonight, we get to watch, I don't know what. I don't know what I found for you guys. It's not soft sittery. You might think so. But he spins a different kind of word salad. And when I think of all the boys to the yard. I don't know what kind of yard the original singer was talking about, but I'm imagining a prison yard for this kid if he keeps it up. His words tell it'll bring all the boys to the yard. Hello, Nana Laura. Hello, Jerry Matthew Boyd. Hello, Buzzy Pug. Hello, Eileen and Carlin. Hello, Wire Mother. Hello there, Patrick B. Hello, Lisette Bennett. Hello, Sandy Hurd. Oh, your comment made me smile so big tonight. She commented on the Facebook post that Chasing Daylight put up for me for the PAWFURM donations. And she said, I'm a blessing to all animals and humans, or something like that, or 2 legs and 4, something like that. It was cute. I liked it. Hello, C-Rex. Hello, Otto. Can you guys hear that? Can you hear Snitch? Snitch is in Ava's kennel all the way in the back. All the way in the back. He is, well, I get where Tiny Kitten gets her talking from. He just doesn't stop. Hello, Charlie. normally I just, whatever, to dismiss Lee's looks, but oh, they're priceless here. I think at one point she even mouths, "What the?" Hello, Donald Westerdale. Hello, Purple Kiv. Oh, Ava is not wagging approval from Snitch. No. In fact, she very much disapproves. Yeah. And Bandit, too. Snitch's cage is right outside of Bandit's door. And when I went in to take a shower, I swear I heard her say, "Dang it, lady. I don't even like the ones you already have. And you brought another one." I swear all I did was open the door. Everyone on Discord saw it. I just opened the dang door. Well, you were there for the story. Oh, not intentionally, but at this point, I mean, I can't throw him back out. We're supposed to get 2 feet. And that's exactly how she came to me on a freezing night. These suckers know my weak spot. I'm the sucker. Who am I kidding? You told me so. Dang it. Oh, I know. Oh, I'm very well aware. That's why the first thing I do is try to set up getting them neutered. Yep. And of course that also comes with all the shots and everything else that I'll have to get. It's probably, I'm guessing feral cats will usually run you about $350, $400 to get them all of their shots and neutered and everything else. Typically, I think that should be all it is around the 300, 400 mark. I hope. Hello, Michelle Moreland, honey. Yeah, I can't handle that Tom smell. Oh, no, no. And when I had Crow, we lived in a trailer. And when we got Crow, he was a feral kitten, and I took him to the vet right away. And they said they could give him his shots, but they couldn't neuter him yet because he had to be at least 4 months old. And they were aging him at exactly 4 months. And because they couldn't age him younger, or I mean, older than that, then, I mean, they couldn't even fudge it and say 5. No, no. They said I had to wait until the next open house to get him fixed. That didn't happen. They didn't run another one. They discontinued them. I believe that was COVID time. Pretty sure, because no, it would have been right before COVID time. Because I bought the house in 2020. I think my butt pillow back there is making my camera not focus. I think it keeps trying to focus on this. I put that there for Tiny Kitten. Tiny Kitten would always steal my chair every time I got up. And so I got my replacement butt pillow. And so I put my old one on the couch for her, so she can steal that. Old Tom Caterwaller. You can keep it. I will not be cuddling up to you. Not with that on. Oh. Yeah, right. I'm her sponsor. Oh my gosh, you guys are too much. Well, I got threatened by it for a couple of days now from your neighbor. She's warned me. And today she sent me a screenshot that said snow starts in 49 minutes. And it was for Toma. It didn't start in 49 minutes, thankfully. But it did eventually start. And apparently there's 2 feet of it coming. Y'all can keep it. I don't want it. Why don't you keep that stuff up in Minnesota? We don't want all of your leftover stormy bits. No, the closest we have is once or twice a year they'll do a event at the fairgrounds here where you pay $25 per cat, or I don't think they do dogs. I don't think they do dogs at the particular event hosted by the animal shelter, but $25 for a cat. I mean, you can't really beat that. Sauk County Humane Society, which is an hour away from me, it's in Baraboo. They had a program every Tuesday that was $30, I believe, to get the cat neutered. I'll be calling around Monday for sure. Yeah, all 65 pounds of her. I guess she crossed their threshold. So, I mean, she's kind of a medium large. When she stands up on me, she's up to here on me. Like her paws go right here and her head's like right here. So I mean, she is a big girl. My little sidekick. Just seeing the Belgian ale comment. There was someone or some TV show. They were trying to figure out how much blood it would take to have enough iron or lead from the blood to make a sword, because they wanted to actually make a sword of their enemy's blood. Like, I think it was a TV show that talked about it. I don't remember though, but I remember that, and that that's what your comment reminded me of. Hello, Jenny Green Honey. Hello, Spider-Man. Let's see, did I get everybody? What is? Oh. A pizzle? A beef pizzle? I guarantee I've never had that. So I just gave my dog braided bull penises? She seems happy. I'm not going to stop her. Hello, Mortimer Duke. Apparently a bull penis. The things we learn on the Searing Science channel. Okay, hold on. Beef pizzle. Oh my gosh. Oh, she's not lying. Beef pizzle, commonly sold as bully sticks, is a popular natural single ingredient dog chew made from the dried muscle of a bull's penis. They have many key benefits. Oh my. Who was the first one? Who was the first guy in the dog treat factory that said, I bet we could use those? Hey, you know what's about 6 inches long and make a perfect dog treat? This is why I'm single, I guess. All the men in the world are actually just terrified of me. They're afraid I'll feed them to Ava. Oh my gosh, my tummy already hurts. Pizzle for shizzle. No, that's marshmallows and gelatin. I made Rice Krispie treats yesterday. I did that. So I've got my horse hoof in. Oh, Well, I could teach you, but I'd have to charge. Oh my gosh. See, I hadn't made it to your comment yet. Oh, this ain't no waffle cookie. And I'm not even going to get into the waffle jokes. Oh my gosh. How uncomfortable did you feel typing that? Oh my gosh. Oh, oh. I will eventually. Eventually. First, he's got to get neutered. I can't have him spraying all over the house. And he and Earl, not so friendly yet. So until they each get used to each other's scent, I mean, never in the history of ever do you let a stray feral cat just walk into your house and mingle with, with no precautions. It's about time for everybody's dewormer anyways. So, because they're supposed to receive quarterly dewormers. So yeah, it's about that time. And yeah, until he gets used to sounds and smells and footprints and everything else, he's gonna stay in that kennel for a couple days. Billy had to do it for three or 4 days before I let him out, and he my baby. Thank you so much, Donald. Oh, I adore you. Oh, I don't know. I don't know how well I'm gonna be able to edit that clip from the pound, because when I was trying to edit it earlier on my phone, I started playing it, and the cats meowing in the pound. I was leaned on my stove because I was standing. I was standing, so I was leaned over on my stove and holding my phone. And so here I am like this, and all of a sudden, floor to forehead, climbs Mr. Earl. From floor to forehead, and then he sat on my head to figure out where the meows were coming from my phone. There was a little bit of flailing around, a little bit, on my part. Maybe a few colorful cuss words. His name several times. He wouldn't get down. Not until I ended the video. So I'm kind of scared to try it again. Earl really he gets invested. He gets invested in those meows that he hears on my phone. Oh. That's awesome. I should put a GoPro on Billy. Tiny Kitten, I know where Tiny Kitten goes. Tiny Kitten goes to the house next door, and she has found a way into the not Lathwood. Latticewood. She has found a way into the latticewood to go under my neighbor's house where the lawnmower and stuff is kept under her porch. So Tiny Kitten would be no fun to watch. She doesn't leave the yard between me and the neighbor. And I told the neighbor about Tiny Kitten and me catching her going under there. And she was like, nah, she's fine. She's not going to hurt anything under there. No. No, no, no. Oh, I hate when it does that. I don't, it's funny. Sometimes it'll auto start, sometimes it won't. It auto starts for me when I accidentally leave it open, but not when I intentionally do it. All right. Did I get everybody? I'm just zooming through now. I'm zooming. Oh my goodness. Oh. Yeah, we'll go with that one. Oh no. I didn't know that they could crack a tooth on it. Even it's kind of like, I mean, I guess. Yeah. It's got like a cartilage feel to it. Now I know why. Yeah, they are. They are. But I tried getting her these. And it's a no-go. Ava says they are not good enough. They are being given to the neighbors because her dogs are far less picky. It says bully slices and it says original bully flavor, but it's a beef hide treat. I don't know if that means that it's rawhide, which I hear a lot of bad stuff about. I don't know anything about it. I should learn why rawhide is bad, but it doesn't say rawhide, but it doesn't say rawhide alternative like all the other ones do. It says highly palatable, slow roasted for maximum flavor, but the flavor is painted on. Oh, they're gonna make me mad. Where's that? Hold on. Where's that piece? Here. Look. The flavor is painted on. So don't tell me that it's slow roasted for maximum flavor. I mean, it's essentially covered in barbecue sauce is what it is. Beefy barbecue sauce. You gonna give it another shot? You're gonna put it on the floor again. Beefy barbecue sauce for sure. Yeah, once I saw that in the little crevices and stuff, you can see just white where the flavor paint didn't get to them. Here's another one. This is the one I was looking for. Look. It's literally just whatever the skin it is, the beef hide that it is, and then painted. And the inside is all white. But well, she's giving it a better shot than she gave the first one. She sure did not like the first one that I gave her. She left it right in the middle of the floor. Oh, my hair is just such a mess right now. I can't get my one bang to sit right. Coming fresh out of the shower. It always has a mind of its own as it dries. Hello, Dark Zoomy. Hello, Space King. Let's see here. Earl's no dummy. We all knew that. You're gonna have a full tummy. There's a lot of them here. A lot. That cat don't know whose house he broke into. I have not watched much of that. I've watched a little bit here and there. But I know that you love that show. Hello, Chris. Oh, no. Let us know. We'll all be praying for you. I'm glad that he's in the hospital, though, because it's the safest place for him. I'm sorry that he has to be there, but I hope he's in really good hands. I suspect that he is. My gal has no problem with him. That sounds like a Mortimer Duke if I ever heard one. All right, guys. The thumbnail dude, the word salad dude, is like the third person in, I believe. He's not going to be the first video. He's going to be like second or third. Palmy? Or Mortimer? I'll know soon enough. Oh, here we go.
Good morning. The person on the Google Pixel, would you please identify yourself?
Hi, my name is Matthew Liebrecht Jr.
Good morning.
Good morning.
Liebrecht, you are appearing for arraignment purposes this morning. Ms. Nisserly is currently on the phone with another client, but she'll be here with us very shortly. And so we'll wait until she is available to assist you, okay?
I'm not
Okay,
sure if
thank
that
you.
was, oops, pardon me. I'm not sure if that was the correct number. It was a stack voicemail, but I did leave a message for the 920.
Okay, thank you very much. This is Mr. Liebrecht. We're on the record in case number 266845SM. Once again, you're appearing for arraignment purposes. This morning, you're appearing with Ms. Mr. Lee, the defense attorney available through the Indigent Defense Council here to assist you. So, Mr. Lee, did you have opportunity to review the allegations on the complaint, nature of the offense, and possible maximum penalties with Mr. Liebrecht?
I did, and we will waive a formal reading of that misdemeanor complaint and enter pleas of not guilty. Mr. LeBrecq is requesting assigned counsel.
Thank you. So in order to complete a petition for court-appointed attorney, I need to place you under oath and ask you some questions. Would you please raise your right hand? And you swear that the information you're about to give me will be the truth to the best of your knowledge?
Yes, Your Honor, I do.
Thank you, and you're welcome to lower your hand. Mr. LeBrecq, what is your phone number
231
and your mailing address?
Traverse City, Michigan, 49686.
Do you also use an email address?
Yeah, it's gonna be at gmail.com.
At the address on Boone Street, are you renting, purchasing a home, or living with others?
Living with my father right now until this case gets resolved.
Are you working?
Yes, I am.
Where do you work?
I'm self-employed through Matt's Custom Painting.
And what is your average take-home pay?
The average take-home pay is about 13 to 1400 a week.
Do you receive any other source of income or assistance?
No, I do not.
Do you own a vehicle?
Yes, I do.
What's the estimated value of the vehicle?
The estimated value of the vehicle is about 19,000.
And do you have any money in a checking account or savings account, any cash on hand, or any digital currency?
As of right now, about 900 bucks.
So I will appoint an attorney to assist you. The next step in the process, the pretrial conference in this case will be scheduled for April 2nd. It's at 9:30 a.m. in person here at the district court. Bond has been set in this case. Ms. Mr. do you have any questions or concerns regarding bond?
Well, Your Honor, Mr. LeBrecq would request a reduction in the twice daily PBTs to once a day. I did look through his CCH, it appears, and he described to me has no alcohol-related driving convictions on his record. Looks like his BAC was a .133. And of course, he is also currently doing twice monthly urine screens, which would also pick up any alcohol. So we, for financial reasons, as well as, the work, and he does have a 4-year-old son, we're asking the court to consider reducing the PBTs to once a day. And he understands that would be in the morning. It's my understanding he has not tested positive on any testing to date. And he did, post, I believe it was $500 on a 5,000 10% bond. So he knows that he'd be putting that valuable money that he needs at risk if he were to violate the conditions of the bond.
Are you using an in-home device?
I am not using an in-home device. I go to New Direction Testing Facility.
Are you able to get an in-home device?
I would be able to acquire one.
It would make it more convenient for you, number one. If you might have to pay to get that device, but ultimately, especially with traveling and all of that, it works out to be at least the same amount of money. I don't think it works out to be any more expensive. Yeah. my concern is, the allegations on the complaint, obviously, you were charged with operating while intoxicated as well as the DV. Your criminal history plays a role in my decision as well. For right now, I'm going to continue the twice daily PBTs, as well as the urine screens. And do you still have your referral form? It would give you a couple of phone numbers to access an in-home device. Do you have that with you or at home?
Yes, I do.
Okay. So why don't you look into getting an in-home device? Community Corrections Pretrial Services may have one readily available. As well, Smart Start is the other place that you can obtain an in-home unit, or it's a portable unit, right? So that can go with you, but I don't know, sometimes Smart Start is a little more time in accessing the device. So you may want to check with Community Corrections first.
Okay, Your Honor.
And from what I understand,
Right.
Smart Start does cost more. So,
Oh, it
Yeah,
does cost more too? Okay.
yeah.
right now I'm at $35 per week for the twice daily.
30.
Yeah, 35 a week, $70 every 2 weeks. And from my understanding, Smart Start is $180 every 2 weeks.
No. It's 80.
No,
It's $84. Wait a minute.
$84? Okay.
84 every 2 weeks.
I stand corrected. Thank you.
Okay.
yeah, no worries. But there may be a startup fee, but you might be able to get that back. It might be
It's $20.
Sort of like a
Yes.
deposit. Yeah, but you can get that back.
Okay.
And again, when you include your driving time and all of that, it might be a little more expensive, but not when you include the convenience as well as the drive time. So the bond will be continued with all of the same terms and conditions. You'll have contact from your assigned counsel by the end of next week. So that person may call or might mail you a letter. Please watch for contact from your attorney. Pretrial conference, once again, will be on April 2nd. And do you have any questions?
Not at this time, Your Honor.
All right. Thank you for your appearance this morning. Please watch for contact from your attorney. The court will mail you the notice for the pretrial conference, and you are free to leave the meeting.
Thank you. I hope you guys have a good day.
You're welcome.
Good luck.
Be careful out there.
Okay, so that refreshed my memory. That is not the correct number for Ms. Wingo. That was the number for an Elizabeth Hepner, who has no idea who Ms. Elizabeth Wingo is. If I don't take very clear notes.
I like it.
Oh.
So let me see if we have a different number. I wouldn't call her out now.
Is Mr. McGrath still on your docket for 9:30?
Yes.
Yeah, okay. Well, we'll see if he shows up. He wanted me to get this adjourned because he's busy with school, and I informed him I was not able to do that.
Never a dull moment, is there?
No, and I always double check and say, nope, I don't see anywhere on the notice to appear where it says RSVP. In fact, it says failure to appear in a criminal case.
Right. Good morning, the person identified with the hello. Would you please unmute and identify yourself? You have your name? Good morning. Can't hear us.
Can everybody hear me?
Oh, We can hear you. Can
Fantastic.
you hear us?
I can most certainly hear you as well.
Oh, thank you very much. May I have your name?
My name is Patrick. Do you want my full name?
Mr. McGrath?
Yeah.
Good morning. So we are on the
Mhm.
record in case number 266847 ST. You're appearing for arraignment purposes this morning. Ms. Mistley is the defense attorney available through the Indigent Defense Counsel who will be assisting you. She has not yet had an opportunity to speak with you. I'm going to place you and Ms. Mistley in a breakout room.
All right.
Before I do that, I do want to verify your phone number. Mr. McGrath, what's your phone number?
My phone number is 3355.
Thank you. So I will place you and Ms. Mistley in a breakout room.
Forget a video game. He thinks he's some kind of nighttime radio DJ.
A place where you can have a private conversation with her so that she can go over the issues regarding the arraignment before we continue.
All
Your
right.
screen will ask you to join that breakout room, and when you're done, you'll return to this meeting, please.
Sounds good.
Welcome back.
Thank you.
We are back on the record in case number 266847 ST. Ms. Mistley, did you have opportunity to review allegations on the complaint, nature of the offense, and possible maximum penalties with Mr. McGrath?
I did, and we will waive a further reading of the misdemeanor complaint and enter a plea of not guilty. Mr. McGrath will be representing himself for purposes of the pretrial. He knows what document to have with him, and he understands he can later request counsel if need be.
Thank you. So, Mr. McGrath, the pretrial conference in this case is going to be scheduled for March 24th at 9:30 a.m. in person here at the district court,
What day is that out of the week?
a Tuesday.
Okay. Sometimes I
So
have
you were not
university
arrested.
to attend.
I'm sorry?
I said sometimes I have university to attend to and or work, so I just have to make sure that I'm able to attend to its request per professor and or other higher ups in order to convey my potential absence from that day, but that should be a good.
So I would suspect that you'd want to prioritize the court as the highest up. A professor can't put you in jail if you fail to appear to a school.
Correct. Yeah.
Um,
Just to allow
so-
them to convey to them that I might be absent that day but yeah.
Oh, thank you. I thought you were saying you might be absent from court.
No.
So, great. March 24th, 9:30 a.m. in person here at the district court. You were not arrested. I'm going to place you on a $1,000 personal recognizance bond, which is a PR bond. You don't need to post any money. It's your promise you'll be at every court appearance and that you will abide by the conditions of the bond. Conditions of the bond are that you may not operate a motor vehicle without a valid driver's license, registration, and insurance. And as Ms. Mistley indicated to you, you've not waived your right to be represented by an attorney. So you're welcome to hire your own attorney, or if you would qualify to request the court appoint one for you if you are not comfortable or satisfied with the outcome of that pretrial conference. I do want to verify your mailing address, please, Mr. McGrath. What is your mailing address, sir?
Wildwood Road, Interlochen, Michigan, zip code 49643.
Thank you. Do you have any questions?
Kind of. I just wanted to ensure that is the information conveyed? Are you able to well, hold on, let me
No, it's blurry.
just. Are you able to convey the information on the other side of this?
No, sir.
But is that because of your perspective is unable? It's mono perspective, right? There's not information conveyed on both sides. Is that correct?
I don't know what it is that you're holding up.
It's information. It could be pertinent information, but you are in agreement that you're unable to convey the information that's on the other side. Is that correct? Because it's not labeled on both sides, correct?
So again, it could be a blank piece of paper on both sides. I'm not sure what you're trying to get at.
I just wanted to make sure that you're unable to discern the contents on the other side of its piece of paper because it's not bidirectional in terms of the conveyance of information. But if its perspective was, i.e., if you were facing the orientation of in which the information was being conveyed, you would be able to discern the information if you were to alter or the information was to be on either both sides or you were facing the proper side in which the information was being conveyed from and not being entrapped from an individual, you would be able to discern the importance of its information on the other side. I just wanted to make sure that you agreed that because of that, you were unable to discern the information on its listed side. I just wanted to make sure that was known. So, but thank you for proving my point. I appreciate that.
Thank you for your appearance this morning, and you are free to leave the meeting.
The only point she proved is that you're an absolute moron. And she did that just by allowing you to speak and nothing more.
Thank you.
Afternoon.
Afternoon. So Leelanau County told me I'd need to do a breakout. I did try to call, but
Okay, they're here. We will go into a breakout room.
all right.
Thank you, and we are on the record in case number 266892 SD2. This is a Leelanau County case that's being heard here in Grand Traverse County. And Ms. Mistley, did you have opportunity to review the allegations on the complaint, nature of the offense, and possible maximum penalties with Ms. Perkins?
I did, and we will waive a formal reading of that misdemeanor complaint and tender a plea of not guilty. Ms. Perkins is requesting the assignment of an attorney.
Thank you. In order to complete a petition for court-appointed attorney, I need to place you under oath and ask you some questions. Would you please raise your right hand? Ms. Perkins, thank you. And you swear that the information you're about to give me will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you, and you're welcome to lower your hand. Ms. Perkins, what is your phone number
616
and your mailing address?
Empire, Michigan 49630.
Do you also use an email address?
Yes, I do.
And what is that?
At gmail.com.
At the Coleman Road address, are you renting, purchasing the home, or living with others?
I own the home, paying a mortgage.
And are you employed?
I currently am not. I lost my job as of Monday.
Are you receiving any source of income or assistance?
Not at this time.
Well, that's a new one. Usually they start a new job on Monday. She lost hers on Monday. Whoopsies.
Do you own a vehicle?
I'm leasing a vehicle.
Do you have any money in a checking account or savings account? Any cash on hand or any digital currency?
No, not at this time.
And so I will appoint an attorney to assist you. The next step in the process, the pretrial conference in this case will be scheduled for March 25th. It's at 9 a.m. in person there at the District Court in Leelanau County. Ms. Mistley, is there information you'd like me to know regarding bond?
There is, Your Honor. So we are requesting the court to release Ms. Perkins on a PR bond. She was extraordinarily cooperative and forthcoming, I believe, when I just met with her privately. She had been employed as a manager of a dental office in Leelanau County for 6 years. Was shocked to have been terminated from her employment on Monday when CPS arrived at the office to talk with her, and apparently they didn't think that reflected well on the office. She has filed for unemployment and will be pursuing that.
Well, See, I bet there's more to that story, Miss Lee, because I don't think somewhere that you've been a faithful employee of for 6 years would fire you just because CPS showed up to ask you some questions. I would think it would probably have to do more with why CPS showed up to ask you those questions. And then the business realizing, holy crap, she is not a nice person. I don't think we should keep her here. This is going to be in the paper or shown on YouTube. Yeah, she's got to go.
She does have 2 prior misdemeanor offenses. She understands that she will likely be testing twice a day. So we would request the court's permission for an in-home testing unit, particularly given that she lives in Empire. She is, well, I won't go there with that. So we would ask for the PR bond with the standard terms and conditions, and the testing conditions that I've already advised her are likely going to be ordered.
Ms. Perkins, I am going to place you on a $25,000 personal recognizance bond. Conditions on the bond are that you may not use nor possess any alcohol, any illegal substance, or any controlled substance, including marijuana, any mind or mood altering substances, or any non-prescribed medication. You'll provide a list of your current prescriptions to the district court clerk. You will take and pass twice daily PBTs proving you're not drinking. You'll also submit to discretionary PBTs and discretionary urine screens whenever requested by a police officer. You may not enter a bar, a casino, or any place that serves alcohol by the glass. You'll have no threatening, intimidating, harassing, or violent behavior towards any person. You'll be respectful of all court employees and care providers during the course of your case. You may not operate a motor vehicle without a valid driver's license, registration, and insurance, nor with the presence of any alcohol, any illegal substance, or any controlled substance, even that which might be prescribed to you. The court's concerned of if it were me and I had 2 significant issues happen at the same time, and maybe 3 significant issues, I might find myself in a very dark place, thinking maybe of harming myself. I'm also going to order that you will seek an intake appointment through community mental health, or have a scheduled appointment with a physician of your own choosing, but you have to provide proof that you've done that by Friday of next week. Please don't leave jail without a copy of the referral form regarding the testing requirements. They begin immediately. Of course, you are welcome to use an in-home unit or a portable device. It's possible that the community corrections pretrial services people may have one that's readily available for you. The other option is Smart Start. The testing requirements will begin immediately. Ms. Mistley, do you have any questions?
I don't believe so. Thank you.
The corrections officer there at the Leelanau County Jail, do you have community mental health that comes in and talks to people?
Yes, we do upon request.
Okay.
I can get her the
So-
information, though, include a contact.
I am absolutely shocked for the judge to be taking this much of a leap. I don't think I've ever had a judge say, if this were me, I might be feeling like I want to harm myself, without a defendant actually saying that they have intentions of harming themselves. Which it doesn't sound like that's occurred. The judge is just assuming or magistrate. The magistrate is just assuming that these events were significant enough that this girl is not capable of coping. I mean, I'm all for ordering people into mental health assessments and treatments, but I'm not comfortable with someone in a judicial authority saying, you know, because I know I couldn't cope, that means that I know you can't cope. Because I'll tell you what, I've been through a lot of crap. And if I were to ever find myself in front of a judge someday, I mean, there's good argument for that on my case, you know, that I might not be able to cope because of the things that happened to me, but I managed. I don't think that she's within her judicial capacity to assume these things.
Okay, very good. Thank you.
You're welcome.
Ms. Perkins, do you have any questions, ma'am?
If I already have a relationship, I've been speaking with my minister at my church. Does that qualify or?
So, I'm not going to discredit assistance that you can get from your minister at the church, absolutely, but I believe that you need to see a professional counselor as well. And maybe with regard to both substance use and other issues. So again, I'm not discounting that at all, and I would encourage that you continue with that, but it's a condition of your bond that you'll seek some professional assistance as well.
Okay, yes, ma'am.
Thank you so much.
Thank you.
Thank you, Leelanau County, you are all set.
And then we have number 4, Your Honor, Bluff Properties versus Levi Board Grant.
Okay. This
Or
is
Bonder.
2062-00162-08. Looks like we have Mr. Bondurant who's here on the Zoom call. Thank you for being here. So just so the parties are aware, a couple of things. I read most of everything this morning, and then about half an hour ago, I provided a bench copy that was a response from Mr. Bondurant and his significant other about the house. There was included text communication, legal arguments. Mr. McCurry, were you provided a copy of that?
Text communication. I've got to look and see if that's.
There were some exhibits that were attached to the response and exhibit
Oh,
1.
right.
Yeah.
Yeah.
I have no problem sending these over a week for you to respond if you'd like, or I'm certainly willing to go forward right now.
Okay, Mr. McCurry, I'll ask you first. I know you probably received this yesterday or so.
Yeah, and I'm good with going forward right now.
Okay. So just so the parties are aware, I did review everything. Mr. McCurry, because you are the moving party, I'll hear from you first, and then we'll check in with Mr. Kiernan, and then we'll let you go again, Mr. McCurry. So you can go ahead.
Okay. Your Honor, this is non-payment of rent, and it involves rent starting with December of 2025 and January of 2026. Included on the notice was pet and storage fees, and the objection that the defendant has made has to do with claiming that the notice is somehow insufficient because it includes things that aren't within the definition of rent. And what I wanted to make sure the court takes a good look at is this argument that the notice is defective is really based on case law that talks about time and manner defects, not the substance or the particulars of the notice. The case law, the IBF LLC versus Hoyft case, first of all, that one is a commercial eviction. So we have the Residential Landlord Tenant Act really isn't in play there. And the language that's sort of pushed for the court to reach the conclusion that this notice that my client gave was somehow defective, says, failure to comply with the notice requirements defeats the court's jurisdiction over the action. An action that is commenced before the expiration of any applicable notice period is premature and does not confer unlawful detainer jurisdiction. So again, notice requirements in that case were really more of the time and timing of the notice. And if it's supposed to be a 20-day notice and you file your lawsuit on the 19th day, well, you're out because you didn't follow the 20-day requirement. Then it says down below, while substantial compliance with notice is sufficient, notice must also be sufficiently particular and certain so as not to deceive or mislead. All right, so the defendant wants to hang their hats on that language and say that, well, gosh, we got a notice that included a pet deposit, and we're just mortally confused by that. If somebody sends me a bill for $50 and I know I owe them 25, I contest the 25 and I pay the other 25. I don't say, well, I don't owe anything and just sit on my hands. So this notion that the language in this case says that it can't mislead people, there's no misleading component to saying that we think you owe us a pet deposit because you admit that you have a cat now. If that's not something that's allowed in a notice, I 100% agree that the court can strike that from the notice, but it doesn't change that the remaining portions of the notice are effective and enforceable. And this notion that because the unlawful detainer statute is in derogation of the common law, suddenly it's strictly enforced. Yes, it is, and that's what that filing on the 19th day as opposed to the 20th is all about. When the law says that substantial compliance is sufficient, that means that some of that stricture is gone in terms of some of the particulars of the notice. And here we have two issues. There's number one, the inclusion of the pet deposit, and number two, we had inclusion of rent for the month that the notice was served, and the notice was served on the second day, as opposed to letting the 5-day grace period run. If you wipe out both of those errors, if they're even errors, then what you have is still at least a month's rent due and owing, and it hasn't been paid. And there are admissions in the defendant's paperwork that say they have the money. They admit that they didn't pay it. The other case that's brought up is the Sherwood Auburn versus Pinzon case, and they're quoting from it says 681. I guess that's the Pacific site, but they're quoting that case for the proposition that adequately and precisely and correctly informing the tenant of their rights as they are entitled. The language that I would quote to the court from that case is where the court said, stating that if a court is so ordered, and then it says, Pinzon and Mendez could be required to vacate the residential unit in not less than 30 days from the date of the notice. These notices did not unequivocally inform Pinzon and Mendez that pursuant to the CARES Act, they had 30 days from the date of notice to cure the alleged non-payment of rent or to vacate the premises. Notice must be sufficiently particular and certain so as not to deceive or mislead. And there, the Pinzon court was quoting the Hoyft case. And then it says, thus, when the notice provided does not accurately convey the correct time period to cure or vacate, the notice is not sufficient. That case highlights what I said in the first instance about the Hoyft case, which is timing is what is the focus of that case law. It's not that the content of the notice has a minor error here or there. That's what's covered by the substantial compliance language. And there are times when I've just let this issue go and gone and reserved a notice, but these folks are well behind in rent. They're constantly behind in rent. And In this case, there's still rent owing, they admit it, and there's no defense to it. They're claiming confusion in an environment where there would be no excuse for confusion.
So let me ask a couple of clarifying questions and then I'll let you chime in, Mr. Kiernan. In looking at the lease agreement that your clients have, this was a lease agreement that was entered December 9th of 2023. The lease amount on that document is $1,375, which is less than what your clients are indicating was the amount owed. Just in the rental amount, has it gone up since that initial agreement in 2023?
I would say there must have been a rent increase in there.
My client does dispute that, Your Honor.
Okay, so then I do see information contained on that lease also has information about this $500 pet non-refundable fee. It says that it's $500 if checked. Pets are allowed subject to the conditions below. Any additional addenda included with this rental agreement, which I didn't see any in my review of the motion. So it does indicate that that $500 is a non-refundable pet fee. What I think is a little bit lacking in the lease agreement is, did they get a pet? There's not really a whole lot of communication. Doesn't really require the tenant to provide notice of, hey, I now have a cat. And then there's a bill provided to the bondurants of, okay, now you have a pet. Now the $500 is due. That's a little bit of a concern because while there's not notice provisions listed in the lease agreement, sending essentially a text message as to act as an invoice as to, hey, you now owe this $500 is a little concerning. Mr. Kiernan, I'll hear from you, and then Mr. McCurry, if you want to provide any responses to those.
So
I'll hear
our
from you.
real problem is that they are conditioning rent on, or they're conditioning that pay or vacate. So they are saying that you need to pay this or vacate. It's conditioning on pet rent. Your Honor, and there is no provision in the lease that says that they can do pet rent. I would ask you to look at 5918-283 or 283-2, which says what they can divide. You cannot evict someone based on a deposit unless there is an agreement at the beginning to treat that deposit as a monthly rent. If there is proof of that in this case, I've not seen it, and that would change my rule or my argument. But that does not appear to be that thing, that pet addendum. So basically, they're conditioning that this is a pay or vacate notice. So my client gets that, and he thinks that it is conditioned on this pet rent. That is why it's confusing or misleading. And if you look at the text messages from my client, when he got the December one, he's like, "Hey, what is this pet rent? We haven't paid it. We haven't done that." So I think that that is a direct violation of 59 or 283.
Holy buckets. You can see when Jeff gets going. He did the head scratch, and then he went into bouncing, and his breathing became more rapid, and wow, he gets himself amped up. He's got to be sitting on one of those office balls that you can bounce on, because that's the only way that I can explain that.
And that is why it's deceiving and misleading. The other reason that this is a huge issue, Your Honor, is if you look at the lease says that rent is not considered late until 5 days after the first. They sent this, and that is in their lease agreement. They sent this this notice that included January's rent on the 1st or on the 2nd. So that is before this rent was due under the lease. So that means my client could not have just paid the amount that was due to get done because that rent was not due. They had to have waited that 5 days before that rent was due, because that notice incorrectly informed the tenant of the rights at the time. That rent was not due under the lease agreement, Your Honor, when that notice was signed. But again, the pet rent here is our big problem. And as you can see, we have textual evidence that says that my client was blindsided by this and he didn't know. He's been paying this rent for a long time, and he was very confused by this charge. So they conditioned rent on they conditioned him staying there on something that was not only not in the lease, but not rent, Your Honor. And that is simply not allowed. There's clearly a material issue of fact here. So if we want to set this to trial, we can. But that being said, I think this needs to be dismissed because Mr. McCreary, I mean, they're not disputing that there's pet rent here. But what he's saying is, oh, this isn't a big deal. Your Honor, the initial rent, the initial amount that was owed in December was $1,500. They added a pet rent and storage fee of $560. You know, that adds a material amount of money for my client. And I would just like to note, they shut off Mr. McCreary's like, well, why didn't he just pay the rest? Why did he do that? They shut off his portal, so he was not able to make any payments, Your Honor, which is what landlords commonly do. But it's really disingenuous of the argument because my client does not have the ability to pay because they shut off his portal.
So, but even though the filings occurred in early February and the allegation was that he hadn't paid December and January rent, even though January rent wasn't due until the 5th of January, he didn't make December payment either, though. Isn't that correct?
No, and I think if they would have filed the initial December, I wouldn't have an argument here. But the problem is the notice is incorrect because when the notice was given, that rent was not due.
Oh, so your entire case hinges on whether the judge sees it as, because December and January were due, and you're relying on the basis that it wasn't served until January's rent had not been late yet. But if they had claimed it as December's rent, then you'd have no argument. But because the paperwork said January, then your argument is valid. I don't know that I agree with you. If they didn't pay in December, I don't give a damn what day the eviction is written on in January, if it's on the 2nd day or the 5th, because they're now a month plus behind.
Okay, but your client didn't pay December rent either, did he?
He didn't, and and if they were moving on that December rent, I would not be able to make this argument, Your Honor, because that rent was due at that time. But I mean, again, this is a derogation of the common law. The landlord needs to file with all the requirements. They did not file with the requirements correctly by moving on that notice. If they would have issued that notice on the 5th, or on the 6th, I couldn't have made this argument. But again, factually, they said that rent was due that was not due. So they did not accurately, for a number of reasons, this notice is just bad, Your Honor, because it did not accurately reflect the rights that my client had. It says that he had to pay $500 pet fee, which again, $500 is a material amount, Your Honor. That is a lot of money, especially when your rent is that much. So to have a factual amount on there that is wrong significantly affects my client's ability to redeem, and it does not accurately display or does not accurately convey what he needed to do that, Your Honor. So I think again they need to follow these notices strictly. They did not do that for a couple of different reasons. Again, the amounts are just wrong on this notice, Your Honor.
Are you talking about on the complaint where it indicates that the defendants owe rent of $14.25 for the month of December, $15.65 for the month of January, and then also listing is it says reoccurring. I'm not sure that
it's not reoccurring though. That's why the notice is factually wrong, because it's not a reoccurring charge and they cannot get that, Your Honor. And again, the problem here is that the notice was just incorrectly informed him of his rights when they had it as a result of this pet rent, and that notice is not due. If they would have filed the December notice, Your Honor, and we would have been here, I'm not saying that he doesn't owe January rent. I'm just saying that the notice was incorrect, and therefore they did not avail themselves to your court's jurisdiction because they were trying to get rent that at that point was not due.
Okay. Mr. McCreary, I'll hear from you next.
Thank you, Your Honor. First of all, substantial compliance is what the law says when it comes to the substance of the notice. Not every accounting of numbers is always 100% accurate, but it is uncontested that December rent is owed and this notice was given properly as regards that December rent. That alone should be enough for the court to sign an order today. But I want to test what counsel is saying in this argument about the understandability or the confusion relating to my client's notice. My client calls out January 26 rent and then specifically calls out December 2025 rent. And then the pet and storage amounts are specifically itemized. Now, if a tenant has the right to look at that and say that they're confused, how does this extend to the real world? And does it not extending to the real world admit that we're not talking about reality as we sit here right now? What do you mean by that, Craig? What I mean by that is if Mr. Bondurant goes to a local restaurant and sits down and says he's confused by the check and he's not paying it, and he walks out, what happens? Well, probably the police are called and he's arrested. Here, he's received a check. What most people would do when they receive that check at the restaurant is they'd say, hey, wait a minute. I didn't order a cheeseburger. Nobody here had a cheeseburger. Take it off the bill. And then you pay the rest of the bill as charged. But Mr. Bondurant gets to come into court today with a lawyer and say, golly, I didn't understand those other things. And then at the same time of saying he doesn't understand them, he makes an argument as to why they're inaccurate. Mr. Bondurant knew his arguments as to why those things were inaccurate when he received the bill. And now he's trying to tell you that it was too confusing. You can't have it both ways. You can't simultaneously say, these things were confusing and I know precisely why they're not accurate. So what Mr. Bondurant's obligation to do was to pay the December rent and say, good luck chasing me over January when you served me with a notice 4 days early. And good luck chasing the pet deposit because the statute says that pet deposits aren't pursuable as a condition of rent, as a condition of occupancy. So when counsel admits that, gosh, if we had given notice for December in an appropriate way, he wouldn't have these arguments. Well, we did give notice of December rent, and it's as clear as a bill at the end of a meal at a restaurant. And to claim confusion to create more court time and legal haggling over this is just a way to try and extend a situation where a person can't claim they didn't understand and can't claim they didn't know that the rent was owing. So we did not commit a notice defect or violation regarding the timing of this in terms of when the notice was served. He got his full 30 days. He got a VAWA notice. All of this is behind us. And now we're saying, all right, was there substantial compliance? Well, as to December rent, it's admitted that there was substantial compliance. The other parts of the notice just fall off at that point. So we're asking that the court enter an order for a writ so that my client can move forward.
Your Honor, may I address some of these?
In a minute.
Okay.
And this isn't a requirement to answer this question. It's maybe more out of curiosity. And I don't have it in front of me. Do the Bondurants have a pet?
I believe they do.
Okay. When was that pet obtained?
When they moved in, Your Honor.
Okay.
But not before, when they signed their lease. See right there? Nope. I'm sorry. If your lease states that there is a fee, a pet deposit, to have the animal, whether I agree with the existence of such fee or not, doesn't matter. If the lease says it, and you sign the lease and then go get a pet and don't inform the landlord, and you just keep living there without paying the pet deposit, that's a problem. $500 is it's a big deposit, yeah. But pets are destructive. So typically when a renter moves out after having rented a place with a cat, usually there's claw marks on the walls and, pee spots on the carpet and stuff like that. Throw up everywhere. It's what cats do. And the $500 pet deposit usually doesn't cover all of the damages. So the tenant lied for however long he was living there. He absolutely should be held to paying the pet deposit. And rent, mind you, that he hasn't paid for a couple months.
They've
In
always had the pet.
In 2023.
I believe so, yes.
Okay. Go ahead.
Your Honor, he's equating this to paying a check. This is absurdly a different situation. This is a highly regulated landlord-tenant field that has all sorts of different highly technical arguments that the landlord needs to say. He's basically saying, oh, whoops, we didn't follow all these things, but you're not supposed to overlook that. Your Honor, this is a statutory proceeding. It's a derogation of the common law that provides the landlords a quicker avenue of possession. They need to do everything correctly, Your Honor. They did not do everything correctly in this case. This is not the same as getting a bill and doing, differently. This is of something that they were conditioning their housing on something that they did not need to pay. So they were confused by it and they were misled into believing that they had to pay a fee that they did not need to pay. It sounds like Mr. McCreary is saying, we agree that they don't need to pay, but they should have paid anyways. There's a couple different things that fails to understand, Your Honor. First off, if you look at the text message, my client tried to do that. He was just like, we don't want to pay this $500. We'll pay rent if you give us another notice. That is in the text messages, Your Honor. But they did not do that. And Your Honor, they closed down the payment portal, so my client could not make additional payments unless he made this $500. So this is, they created a barrier to do that, which they are allowed to shut off the payment portal, but it makes it really challenging for my client to make the payments there. So it's not the same where just pay what you can and do that. They will shut off the portal if you do not pay the exact amount that they say is owed. And my client tried to work this out, but you can see the landlord never responded to him. He attempted to work this out without going to court. He tried to talk to them. He received no response from the landlord, Your Honor. So my client was trying to work this out by just saying, hey, what's this pet deposit that I've never seen? So again, the real issue here is that they conditioned rent on something that was not owed. Even if the security deposit wasn't paid, Your Honor, under 283, they cannot evict it unless there was an agreement at the inception of tenancy to pay that monthly, which at this point, if he was paying it monthly, he's probably paid it off, but they cannot evict over that. And that is the fundamental issue here is the notice did not accurately inform my clients of the rent because it conditioned rent on something that he did not need to pay.
Okay, thank you to the parties for all your information. Here's what the court's going to do. I'm going to set this case for a trial. I do feel that there are, I think, many material issues of fact that need to be fleshed out through either briefing or testimony that the court can do at a trial. And I'll tell the parties, here's my biggest concern. We have a lease agreement that was started with this family in December 9th of 2023. Then approximately 2 years later, this family gets a text message, and that's all that I have before me, which is my basis for putting this for a trial. All that I have before me is that a text communication to this family that, hey, the pet that you may or may not have, I'm not sure, that you may have had for 2 years, now we want you to pay an additional $500. While they're entitled to do that, because the lease agreement does provide for, yes, you have to pay $500 in a non-refundable pet fee must be paid before any pet is allowed. So then it draws a question of, was it allowed? Were these holders of the lease agreement in agreement to potentially not paying that Because, I mean, someone could make an argument of and there's I just got a a chat communication.
Yeah, that's for
from-
my client. Mr. Bondurant,
Okay.
we're going to deal with all these at trial. Don't
Okay.
worry about that, Mr. Bondurant.
I just wanted to make sure I wasn't missing something. That's not a determination that the court has to make today, because as I indicated, we're going to set this for trial. But I'll just tell the parties that that's my concern, is I can't tell from Mr. McCurry's holder is that they may very well have the ability to collect on that $500, but I'm not sure, because the only thing that I have in front of me is this lease agreement that was signed by the parties, and then text communication from Mr. Bondurant essentially saying, what, we have to pay $500, and that needs to be fleshed out more, because it is a material issue of fact as to was it paid, was it not paid, is there a pet, when was that pet there, if that can be fleshed out at the time of trial. I'm not sure if the court is accepting of the arguments about the summons agreement, and in the complaint, it does allege information related to the defendant's amount owing. That's why I asked the questions related to December. Yes, it does indicate that the January rent has not been paid, although that argument doesn't hold a whole lot of weight, because the December rent wasn't paid either. So it's a bit of a concern to the court. I think the court could move forward, but because we have these material fact issues related to the pet amount and how the $500 was either paid, not paid, when it was paid, that needs to be fleshed out at the time of trial. So that's what I'm going to do. I want the parties to chime in. Is there a requirement to place the rent amount in the court registry because the court is indicating to set this matter to trial?
No, but I mean, no. My client could continue to pay rent into the court register if he wants. I mean, because one of the issues here is that the portal's closed down, so he can't pay rent, Your Honor.
Okay. And Mr. McCurry, I'm inclined to order that because I'm setting it for a trial. I would like that.
I would be fine with the court ordering that all the rent be paid into the registry. We haven't received rent through February or March, I believe. So
Okay.
I think there's 4 months worth of rent there that is owing. And Your Honor, my argument is that my client's notice stands on just the rent. I don't want to go have a trial over a $500 pet deposit. I would waive that argument and waive that issue in favor of just getting an order for a writ because the rent wasn't paid.
Mr. Kiernan, what's your response to that?
No, I mean, there's a question of if the amount of rent was due or not due, so that if the notice was incorrect. Because if you look at the December text that my client sent, Your Honor, he was saying, please send another notice without the pet rent. We will pay that. So I think we at least need to say that my client was trying to make these payments. So I think it'd be absurd to issue a writ when these issues are still outstanding, Your Honor.
So
But it's a non-issue if we waive it.
hang on. Mr. Kiernan, if the court were to order that Mr. Bonner pay,
we would likely have done a payment plan, Your Honor. So I mean, we could set this over a week for us maybe to come up with a payment plan, Your Honor. But I mean, our issue is the notice, Your Honor, and that's kind of the problem.
Okay, so here's what we're gonna do.
And that's jurisdictional. I sorry to cut you off,
understand.
but the notice is, if they do not have a correct notice, you do not have jurisdiction to create this. So I think we at least need to litigate that, Your Honor.
Okay, I understand that. So here's what we're gonna do. I am gonna set this to the 18th for the trial assignment calendar at 9 a.m. So that we can obtain a trial date. Because I kind of sprung the issue of payment, and the court's focused on not so much March, because we're not done with March, December, January, and February. Because I'm essentially prolonging this case, because I do believe there are probably multiple issues and material facts that need to be determined at a trial, not just the pet issue, also the jurisdictional and the notice components that can be decided at the time of trial too. I would like for December, January, and February rents to be paid, because this is going to prolong the action in obtaining that trial date and going to it. But if I'm going to hold off on making that decision, because I think that Mr. Kiernan can talk to his client and provide an update to the court as far as if that's feasible, if there's a payment plan that needs to be talked about, and I'm going to give you guys an opportunity to do that. So I'd like the parties to be back on the 20th as well and have an update on if those 3 months can be paid into the clerk's registry, or if a payment plan can be determined, and I'll hear updates from the parties to that, but it needs to go to a trial. These are just issues that clearly are material, and the trial Courts, whoever hears that from a judicial officer can make those decisions at that time.
All right. Thank you,
And
Your
the
Honor.
court's not ordering March rent, though?
At this time, no. If the parties want to chime in on it, about it, Mr. Kieran, you can talk to your client about all 4 months.
Yeah, we can talk about it. Given your ruling, honestly, I think we might be able to just sort this out.
Okay. Okay. I
All
think
right.
that's
Thank you, Your Honor.
all for today. Thank you.
Thank you.
Have a good day.
All right, the court will call the case of the state of Michigan versus Alvin Gray, 20.
All right, guys. So this hearing, this is a very emotional trial that it ultimately what we're seeing is the pretrial hearing previous, and then we're going to go into the sentencing. I was talking in Discord about this case, and a couple people had seen it on other channels. A couple people hadn't seen it. What I have though is the hearing before yesterday's hearing or Friday's hearing. So it adds a little bit more context. But I am going to warn you, it's a tearjerker.
By S.
Ashley Phelps for the people. I'm another term to pass this to Greg. Greg, can you please state your name for the record?
Yes, Alan Thomas Gray.
Your Honor, we are here for a pre-trial. Can we approach?
May.
Thank you.
Sir, you stayed there.
Yeah.
All right, go back on the record in the Gray matter. We're gonna have a chambers conversation regarding this particular matter. Sir, you can have a seat, okay?
Gray matter. That about sums it up right there.
Thank you.
All rise.
You can call me with the name. Yes, Your Honor.
Counsel. Oh, are you ready to recall the Alvin Gray matter?
Yes, Your Honor.
Roll call case of the state of Michigan versus Alvin Gray, 25S00454.
Ashley Phelps for the people. Can I another on behalf of Mr. Gray? Can you please state your name for the record again?
Yes, Alan Thomas Gray.
Thank you.
Your Honor, Mr. Gray is wanting to plead guilty as charged on this. There is no offer or sentencing agreement. So he wants to do.
All right, Mr. Gray, it's my understanding, sir, that you're going to be pleading guilty as charged in this particular case. You're charged with moving violation causing death. That is a misdemeanor, carries a maximum penalty of up to 1 year and or $2,000 fine plus court costs. Do you understand that, correct, sir? All right, understanding that, please raise your right hand to be sworn. Do you swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth? Thank you. You may lower your hand. I'm gonna go over the rights that you have, sir, that you're gonna be giving up by entering into this plea. Please stop me if you have any questions or if you feel like you need to speak with your attorney again, okay? I need you to answer out loud, please.
Yes.
All right. You have the right to have a trial by a judge or a jury on this original charge, at which time you can call witnesses to speak to you. You can get an order signed by me to require that those witnesses come to court. You have the right to seek, hear, and question any and all witnesses that are called against you. You have the right to be a witness for yourself. Or you could decide that you want to remain silent. If you chose to remain silent, the prosecutor could not comment on it. In addition to that, you have the right to be presumed innocent unless proven guilty beyond a reasonable doubt. Do you understand those rights?
Yes.
You understand you're giving them all up. You're not going to be having a trial of any sort.
Yes, I did.
There's no automatic right to appeal this decision. So in all likelihood, the choice you're making today is going to stick with you. Do you understand it?
Yes, I did.
If you're on probation, parole, or bond when this occurred on August 3rd, 2025, you could be in violation of that probation, parole, or bond. Were you on any at the time? Were you on probation, parole, or bond?
No, no, I have never been.
Anything. That's what I was told. And if you're not a U.S. citizen, there could be immigration consequences. Do you understand that?
Yes.
All right. to the charge of moving violation causing death. How do you plead?
Guilty.
Anyone promise you anything to get you to plead guilty today? Anyone? No, that's okay. Anyone threaten you in any way, shape, or form? Right, let's turn to the date of offense in this case. On August 3rd, 2025, were you operating a motor vehicle at the vicinity of I-94 and Wyatt Road here in Ypsilanti Township?
Yes, it was.
And while you were operating that motor vehicle, and that's on Highway I-94, correct?
Yes, it was.
Did you commit a moving violation by crossing the line and striking
Yes, I did.
Mr. Dennis Littlejohn?
Yes, I did. I fell asleep at the wheel. It's terrible. It's terrible, terrible, terrible thing.
And as a result, he passed away. I find that there's a knowing and willing guilty plea to the violation to the charge in this case. Are you satisfied, Madam Prosecutor?
You are satisfied that the defendant has made a record that he failed to exercise due care and caution on that date, if we are satisfied with the plea.
Thank you.
Defense is satisfied, Your Honor. Thank you.
Thank you. So we need a Friday date. We're gonna do this on a different.
Yes, Your Honor, thank you so much. And for our Chambers conference, I did request a special date for sentencing. I appreciate the court accommodating that.
Yes.
And Your Honor, if I may add, we were hoping for, I mean, I know that given that it's a special date and you have some trials, March is typically a trials month, your dates are limited likely, but we would ask for a date after March 12th, 13th. I believe it would be helpful to have the sentencing after those dates, given he has multiple appointments upcoming in March.
Not opposed.
All right.
The only date I'm not available is the 27th.
All right. What I'm thinking is that we can schedule it at 8:30. If we have to have a trial, we start our trial late. Schedule it for an hour.
They went on 13th or the 20th. Miss Lundy from available on the 27th. Those are our only two options because we have selection on the 6th.
Let's do it March 20th.
I'm not in town that day, but if it's okay, Mr. Gray, one of our other attorneys in our office.
Well, the only other option is March 13th. You said after the 12th, right?
That means 12. 11, okay. So the 13th should work, Your Honor.
March 13th, 2026 at 8:30 a.m.
Thank you for your flexibility, Your Honor.
Thank you, Your Honor.
Thank you. Thank you, sir. See you then, okay? We need to give you your numbers. And you need to go across the probation because they need to give you an interview date. They interview you. We had to make their recommendation.
So I understand that it was a little bit difficult to hear in the courtroom audio, but there's a couple of things that I need to point out with what they were saying that may not have been obvious. What he's convicted of is a moving violation causing death. He stated that he fell asleep at the wheel, crossed the line, and struck Mr. Dennis Littlejohn. So that is why it is a misdemeanor offense, because that's going to be the next question in the next hearing, in the sentencing. Why is it a misdemeanor? This answers it. Despite anything else that happened that night or that was discovered later, the only thing that they could get him on was a moving violation causing death.
What?
Is that here?
Yes, that's here.
They'll walk you.
Someone's gonna come and get you and walk you over there. Okay? All right. Thank you.
Thank you.
You're welcome, sir. All right, the quote call case of the state of Michigan versus Alan Gray, case number 25S00454.
Morning, Your Honor, after Lonnie Belkis for the people of the state of Michigan. Can I judge on behalf of Mr. Gray? Mr. Gray, can you please follow me here? When you get up here, can you please say your name for the record?
Yes, Alan Thomas Gray.
Thank you. Good morning, Mr. Gray. All right, we are here for sentencing today.
Yes, Your Honor. I've had the chance to review the PSIR with my client. Please let me know whenever you're ready for us to continue.
You said what? No, I didn't catch the,
Sorry, I know I usually, you usually say something before you usually ask if we've reviewed it with our client. We have reviewed the PSIR with our client.
all right. Are there any corrections, additions, or deletions?
I believe there's one part about his health. It mentioned needing surgery to remove a tumor. I would just correct that to say that he has a lesion on his knee and may need surgery. It's not cancerous. It's been found, he found out since the PSIR that it's not cancerous, but he still may need surgery. So that's the only correction. Other than that, Your Honor, we don't have any corrections, modifications, or deletions, but we would ask Your Honor not to follow the recommendation with regards to the jail time on this case. We understand the heaviness of this case. We understand how serious this case is. Mr. Gray understands that, you know, the actions that he took on that day led to this horrific, result. He understands the pain and the agony that he's caused. He's deeply, deeply regretful about this. He is absolutely taking responsibility for his actions that evening, Your Honor. He wants to pay for his actions. He's, going to do whatever Your Honor orders him to do. However, Your Honor, we don't believe that him going to jail would serve, any purpose of punishment in this case. We don't believe it would serve a retributive purpose. We don't believe it would serve any incapacitating purpose, a deterrent purpose, or even, a rehabilitative purpose. Mr. Gray hasn't missed a court date. He hasn't had any bond violations. He hasn't had a positive test. He tells me he hasn't drank since the day that this happened and never plans to drink ever again. He's been in constant contact with.
Wait. I hope you didn't miss that part. He hasn't drank since this accident and doesn't plan on ever drinking again. That's going to be an important piece.
In community corrections. He's been honest with Your Honor. He's been honest with probation. He was completely honest during his communication with regards to the PSIR. He does have serious health issues, Your Honor, and if it weren't for that, what we're saying here today would be different. But he has heart problems, and he just had an open heart surgery in December. He's still recovering from that. He just got cleared to work again. He will be taking medications. He has a lot of different medical appointments that he needs, both for his heart and for his lesion. I think he has lymphedema in his legs as well. He needs to be exercising it. He needs to be doing his heart. He needs to be doing physical therapy. And again, potentially a surgery for his knee. We believe that, sending him to jail for a month, as the recommendation recommends, would set him back, for his ability to work because of his heart. He just got cleared to work. We would worry that would cause further delays in his ability to recover, his ability to work, his ability to pay
I'm sorry. There's a lot of Someone died.
I understand.
Go ahead.
Oh, yeah, go ahead. But choose your words wisely, for they may be your last.
and he wants to be able to pay the family the amount that is owed. He understands that that's not going to bring them their son back. We know that that's not going to, change what happened, but the minimum he could do in this case is pay the restitution. And, being sent to jail is going to delay his ability to be able to pay that. It's going to delay his ability to complete any of the probationary terms, Your Honor. He wants to be able to do his community service and give back and, go to church. That's all he wants to do. He wants to work, wants to go home and take care of his health. Again, deeply, deeply regretful of his actions. Every time we talk, our conversations are really long because he tells me about, his deep regret, his deep, how sorry he is, how badly he feels for the victim's family, how he wishes he could change what happened on that day. I was going to talk more about, his work and, how he's getting closer to being able to work, to be able to pay the restitution, but I won't go into that any further, Your Honor. We just wanted to say that he's deeply regretful. You can hear it from him himself.
Absolutely. Wish this would never happen.
It's not quite your time yet. I'll let you know when it is. Okay, sir?
Thank you.
Nothing further.
You may have a seat.
Additions, corrections, deletions, Your Honor?
Yes.
Starting first with the spelling of the defendant's name. It's ALLAN on the first page, and on the third page, it's spelled EN. It should be corrected to AN.
Thank you. I will make that correction.
Thank you, Your Honor. On the first page, there's no victim listed. There was a victim in this case. His name was Dennis, DENNIS. Last name Littlejohn. It's also on the complaint. If that makes it easier for Your Honor to make sure that that's on the PSIR. The people would appreciate it if it was.
Thank you. I will certainly add the victim's name in this report.
Thank you, Your Honor. I have two more whenever the court's ready.
I am ready.
As to the recommendation, it does contemplate a term of jail in advance of a probationary term. So if the people would request that condition complete MAD and victim impact data within 45 days of sentencing be modified to within 45 days of sentencing or release from jail. It doesn't seem realistic to have a 30-day or whatever jail sentence and then do the victim impact panel in a relatively short amount of time.
Okay.
As well as the next one, which is to enroll in complete cognitive behavioral therapy within 14 days of sentencing. That may be an impossible condition, so it should be within the date of sentencing or release from jail.
Thank you.
Those are the summary of my corrections and additions. I've had the opportunity to speak with DJ, that's Mr. Dennis Littlejohn, goes by DJ, so that's the name the court will hear this morning, is DJ. I had a chance to speak with DJ's aunt Kelly this morning, who is here. She brought with her a celebration of life pamphlet and some photographs of the family. I've shown them to defense counsel, and she asked if the court would consider looking through them.
Thank you. Objection.
No objection, Your Honor.
Fine. Yes, you may go.
I understand these photos are of different times that the family would like to go camping at Bishop Lake all together, and then the celebration of life pamphlet from the funeral.
Thank you.
Hold on, please. Yes, take your time. Thank you, Your Honor.
Thank you. I have reviewed it.
Thank you, Your Honor. If it please the court, I'd like to save my comments on the recommendation till after the victim impact statements. Thank you. First, we have 3 victim impact statements this morning, Your Honor. The first would be from Kelly Chin, DJ's aunt.
All right. Thank you.
She's president of the Oh, does Carrie want to go first?
Ms. McQuaid.
Ms. McQuaid, Carrie McQuaid is DJ's mother. I'm not sure if she wanted to go first.
Good morning, Ms. McQuaid. If you want to go first, you can unmute at this time, state your name and begin your statement.
Good morning. My name is Carrie McQuaid. Okay. Good morning, Your Honor, and thank you for the opportunity to speak to you briefly about my son, Dennis. As everyone else knows him as DJ. On the morning of August 3rd, 2025, I was calling my son because I knew he had ran out of gas on the side of the freeway. My last words to him were, please be careful. It's so dangerous and I love you. Something came over me, Your Honor, and I kept calling. I wasn't getting no answer until my son, Aaron, picked up his phone and notified me that Mr. Gray had hit my son. My son, Aaron, had to pick DJ out of the street while Mr. Gray sat in his car and offered no help. All he had to say was he was sorry and he fell asleep. Mr. Gray has single-handedly devastated me and my family. He has taken my son, my other kids' brothers. He's taken a dad, a nephew, a great friend, a great cousin. DJ had made some really poor decisions in his life. And he did his time and he came back a better man. He fought so hard to be accepted into society after going to prison. And he was. Mr. Gray took it upon himself to go to work and go and do whatever he had to do and go out and drink and fall asleep and decide to drive, which ultimately ended up with Mr. Gray hitting my son and causing his death. Since the beginning of all of this, it's always been, I've heard Mr. Gray health, Mr. Gray this, Mr. Gray that. It's been minimal about my son. I don't have my oldest son no more. I don't have the glue to my family no more. It has crushed us all. And I don't know how we're going to get over it. Because I'm forced to live this new normal without my son. Don't do nothing. I sit in my room day after day and cry and just look at his pictures and wonder why it had to be my son. All he was trying to do was get home, and he didn't make it. Your Honor, I am asking you to give Mr. Gray jail time. I understand that it will not bring my son back. However, it has to be a tone set for poor decision makings, especially when they end up in the court. Mr. Gray has taken my son away from me. He has taken my son away from his children and his siblings and his aunts. So, Your Honor, I am asking you to give Mr. Gray jail time. And if you don't feel that the maximum jail time is okay, then I would at least ask you to give him 18 days. 18 days in Washtenaw County Jail. Because for 18 days, my son fought for his life until he couldn't fight no more. For 18 days, I had to sit there and watch my son wither away to nothing. And all Mr. Gray had to say was about his medical things that are wrong with him. I have things that are medically wrong with me as well, but I would never try to push it off as him. And I've always just heard Mr. Gray's health, Mr. Gray's heart. Mr. Gray is so sorry. Mr. Gray, I don't think did it on purpose, but he did it. And for that, there has to be some type of consequences for him. I appreciate your time. Thank you, Your Honor.
Thank you. I know how hard that must be, and I thank you. Thank you.
My name is Kelly Chen. I'm DJ's aunt. Carrie is my sister. And I wrote a statement today that I'd like to read. Please bear with me
Anytime.
if it takes a second. First, I would like to take a moment to thank you, Judge Washington, and the Washtenaw County Court System for allowing me to speak on behalf of Dennis James Littlejohn, known as DJ to all who loved him. My name is Kelly, and I am proud to say I am DJ's aunt. Carrie is my sister. Words cannot express the loss suffered by so many, such as DJ's siblings, children, extended family, and friends, which include yet are far more than the names listed here. Carrie McQuaid, DJ's mother. Elaine Littlejohn, DJ's sister. Derica Littlejohn, DJ's sister. Aaron McQuaid, DJ's brother. Raheem Summers, DJ's brother. Malik Summers, DJ's brother. Malachi Littlejohn, DJ's son. Kari Littlejohn, DJ's daughter. DJ's nieces and nephews, Shania, Alea, Kamani, Marley, Mari, KK, Jamal. And this is only the immediate family. There are so many more extended family and friends that will forever feel the loss of such a bright light in this world. I would like to take a moment to speak on DJ's behalf. You see, like many of us, DJ learned things the hard way, causing him to be incarcerated for a total of 7 years. However, when DJ returned home, things were different. He knew that life in the streets was not the way to a good one. So he began to work and work and work, and then came Malachi, which made him work even harder, to be a good father and a friend. And when Kari, his daughter, came, it cemented the fact that DJ wanted to do better and be better for his family and friends. You see, DJ pushed people to do their best, to dare to dream of a better life. And he was taking everyone with him, always encouraging, saying, "We got this." DJ also chose to go to church and be saved. See, DJ also spoke on the fact that he wanted his children to be raised right, so they would never put themselves in situations that could cause them harm or trouble. Here are some of the things we will miss about DJ. You see, DJ will never be there for another birthday, for his mother, his brothers, his sisters, his children, his friends. He will not be in any more camping trips to take the kiddos midnight fishing, which they all loved, or to yell out "last one down the hill is a rotten egg" to the kiddos, or watch his nieces and nephews and cousins and more play their school sports. DJ will not be there to take his daughter Kari to any daughter-daddy dances, or to teach Malachi how to throw a football or play basketball. I remember camping in 2025, DJ's son Malachi caught his first fish on a midnight fishing hike, and how excited he was. No more wagon rides, no more swimming, no more volleyball games with his cousins, to be continued because of the rain. As DJ would say, no more crazy Walmart trips for camping supplies. No more Christmases, no more Thanksgivings, no more Easters, no more New Year's, no more Halloween. It was heartbreaking when DJ's son said, "Can Daddy come home from heaven now? I want to go trick-or-treating." All taken away by Mr. Gray's action. Bad choices. Sakani, DJ's nephew, is due to arrive in May, born to his brother Raheem and his sister-in-law Coco. He will never know his uncle DJ. DJ's brother Aaron recently got married to his beautiful bride, Janae, and DJ couldn't be there for that either. Nor did DJ get to see his children grow through school, be there for all the things dads are there for, all of the things that family and friends should get to share. No more of DJ's encouragement for any of us. You see, there are many crushed over the loss of DJ. We have all been given a life sentence without DJ, including the mother of his children, Gabby, who will now raise DJ's children, Malachi and Kari, without their father. And she has been assigned the task of explaining why Daddy never came home. You see, DJ's love was infectious and in such a way that you can never forget it. He had the ability to make people believe in themselves and strive to do better and to be better human beings. DJ was always willing to help anyone in need, and the world definitely can use all the good it can get, all taken away due to poor choices Mr. Gray has made. I have watched my sister withdraw from life, lost and unsure. She has created a shrine in her room for her son DJ, which is where she spends most of her time, as this is where she feels closest to her son. No longer will his brothers and friends be able to throw a football, play basketball, barbecue, or just hang out. Again, because of Mr. Gray's poor choices. I have always told my boys, all three of them, in life, for every action there is a reaction. Whether it is good or bad is up to you, depending on the choices you make. And this brings me to Mr. Gray. I can say this, Mr. Gray, I forgive you for being the cause of my nephew DJ's death. You see, forgiveness is for me, not for Mr. Gray. I refuse to hold animosity in my heart. However, make no mistake, I will never, ever forget what Mr. Gray did. When he so carelessly took my nephew DJ from all of us, this entire situation has changed our family forever. I do hear Mr. Gray speak often about delays due to his health issues, whatever they may be. However, my sister too has health issues. She has stage 3 CKD, which is chronic kidney disease. She has beat cancer once, and we are hopeful that she will beat it again because she has it again, as well as a slew of other health issues. The latest being severe depression and stress, which are horrible for my sister's CKD. Yet she shows up every time, as she always has in life. It is my opinion that the state of someone's health should have no bearing on the outcome today, as I am aware that there is health care for those incarcerated, and Mr. Gray's health is not out here for sentencing today. The act that Mr. Gray chose to commit, which is driving while sluggish, groggy, or any other word that may be used to excuse Mr. Gray's actions, which is what is on here for sentencing today. All the police report shows is a lower level of alcohol, apparently under the legal limit. Also shows that Mr. Gray failed every other roadside sobriety test. That being said, it is my hope today that Mr. Gray received the maximum amount of jail time by law, as all of DJ's loved ones have received a life sentence without him. In addition, it is my hope that Mr. Gray will pay restitution for the funeral and all the expenses that DJ's death cost. There is no price tag big enough to put on a human life. Mr. Gray has taken away my sister's son, DJ. I'm sorry. And forever stolen a piece of many people's hearts. You see, I cannot hate Mr. Gray, as I do not even know him. However, I can hate the act that Mr. Gray committed against my nephew, DJ, and his family, whether intentional or not. Mr. Gray knew he had been drinking or reportedly taken narcotics for pain, although Mr. Gray did state he did not take them that day. And only he knows the truth in that. It appears to me in each court appointment, I have watched it become about Mr. Gray's health, which is not on track here for sentencing today.
So he admitted to taking pain meds, but said he didn't take them that day. And he was under the legal limit, but he failed all sobriety tests. I don't believe him in his claim that he didn't take pain meds that day. Because if you're under the legal limit, you should be able to do the field sobriety exercises. Unless there's another contributing factor. I don't believe he just fell asleep. It gets brought up again later. They hash out even more of it, but that's a point that I really wanted to make sure everyone else heard too.
And I feel it is an attempt to get a reduced sentence or no sentence at all. What message would that send to the masses? Whether we call it murder, involuntary manslaughter, careless driving, the end result remains the same. Dennis James Littlejohn is no longer with us, lost at the young age of 30 years old. And it is my hope that justice will be served. Justice will be served. I am hoping to have some closure for my sister and her family, knowing that justice has been served. You see, nothing Mr. Gray can ever say will change what he did. He killed my nephew DJ because he chose to get behind the wheel while in an unsafe condition, sleepy, so he says. And to me, that is an unacceptable response. You see, Your Honor, this is not the first time this has happened to our family. My mother was hit by a car and killed at the young age of 38 years old. And this tragedy has reopened old wounds. And we are reminded of how losing a loved one so carelessly affects the entire family forever. Left to try to learn how to cope, to find a reason to smile again and carry on with life. And there is no sentence greater than that of losing a loved one, especially in a family as close-knit as ours. You see, DJ touched the lives of all that he met. He had a heart bigger than the Grand Canyon, a character that made us laugh, made us believe in life and the fact that it could be better, and the drive to succeed, to surpass all of his own expectations and to teach others to do the same. DJ's irreplaceable and will forever be missed and all we do. In closing, again, I'd like to thank Judge Washington and the Washtenaw County Courts for allowing me to speak on behalf of my nephew DJ, who cannot be here to speak on his own, although he is here. It is my hope that justice will be served here today with the maximum imposable sentence allowed for Mr. Gray. I pray that this incident and the death of Dennis James Littlejohn that Mr. Gray has caused remains in the forefront of his mind each and every day, especially every time he gets into a vehicle for the rest of his life. You see, DJ was not given that option, as Mr. Gray took that away. Thank you for opportunity to speak, and you've already got my pictures.
Thank you.
Thank you.
We have just one moment, please, your Honor. Yes. I think we're not gonna have any more statements from change of plans. The people would ask that the court adopt a recommendation. Commission has prepared. I have nothing.
Thank you. You may return to the podium. Thank you. Anything you'd like to say before I go to your client?
Nothing further from you.
Mr. Gray, now is your opportunity to speak. And the reason you do that is because it's important for you to hear from the family before you get a chance to speak. What you have to say today, very important for them and very important for me, very important for you, and very important for the whole community for that matter.
I'm deeply, I can't say how sorry I am. I wish this would never happen. Because when I walked out my door on the August 2nd, evening to go out, I would have grabbed myself and said, your life's gonna change forever. I drug myself back in a bit back for mercy of the family. I'm beyond sorry. I can't say sorry enough. If his mother was standing here, I'd kiss her feet. I'm beyond, I'll live with this for the rest of my life. I'm remorseful. I'll be in repentance for forever. I beg for mercy. Beg for mercy. I'm beyond sorry and apologize. I'm so sorry. Please forgive me, please. Beg for mercy. Say sorry. I know how much my mom loved me, and I know how much I love my mother. And just said I can't say enough. I can't say sorry enough. I'll be sorry forever and ever.
This particular case is extremely challenging. Some judges take the time and sit down and they write a statement that they're going to say at occasions like this. I choose not to do that because I want to hear what everybody has to say and I want to respond directly to that. You, to the family, to his mother. I think the defense said that this case is extremely heavy, and it is. Any time when life is lost, it's extremely heavy. When a young life is lost, it's even heavier. When you have someone who is so connected to so many people, it's beyond words. And I knew today was going to be heavy. But it's heavier than I could have imagined, to be honest. No matter what I do today, it's not going to bring their loved one back. It's not going to make their life the same again. That's never going to happen. Because like they said, it was your choices that day. And it wasn't just one choice. As I read through the report, it was a multitude of choices. You took Norco earlier in the day. You drank. You went and hung out with a friend. You left at 4 a.m. in the morning. None of those choices were the right ones, obvious. Our society is guided by the laws. The laws say that in this particular case, you're charged with a misdemeanor. So you're in misdemeanor court, where the maximum penalty for this offense is 1 year. I couldn't do any more than that if I wanted to. The other problem is if you do 1 year, then there's no probation. Because you can't give somebody the entire sentence and then put them on probation too. But I don't look at this as just a punishment. I gotta look at the actions that you did take and fashion a sentence that takes that into consideration. The problem is there is no sentence that fixes this. It just can't be done. This is hard, and you caused it. But it's my job to come up with what's best. My problem with you is not every choice that you've made since then, but as I read through your statement and I listened to what your attorney has to say, the family's correct. It's a whole bunch of you, and your health. And I'm not suggesting that I don't take that into consideration, but this is not all about your health. There is, medical treatment in the jail. It is not the same as outside of the jail, and I know that because I've been a part of the system for a long time. So I don't want this to be a death sentence for you too. I'm concerned about that. But the bottom line is, I quite frankly think that the recommendation is appropriate. I considered more time. And I had to think about whether I wanted to give you more time because I'm angry or because I think it's the right thing to do. And as I think about it, I think it's because I'm angry and I'm paying for the family. But that's not the job I have. The job is to do what I think is, in terms of right, what the consequences should really be. Mom has said that, 18 days. 18 days, she watched her baby. Basically, 18 days. She watched him leave this life. There's nothing I can do that can fix that. I have to take into consideration your past record and the actions of that day to come up with the right sentence. And what I think of as your level of remorse. And I get that you are remorseful in the sense that you're sorry, but sorry can't fix this. And I'm going to follow the recommendation. I'm going to impose sentence at this time. It is the sentence of the court that you serve 365 days in a Washtenaw County jail. Credit for 0 days served. You already served 30 days in the Washtenaw County jail. The 335 are suspended. And they're suspended as long as you do what you're supposed to do. If you don't, then I'm just going to give you the full sentence. I know it doesn't sound to you like it's fair. There is no fairness in this at this point. You're on probation for 24 months. There is no early discharge. You're to complete 400 hours of community service at a location chosen by the victim's family. I understand that there's a pending lawsuit at this time regarding the restitution.
I don't think that the pending wrongful death suit includes the restitution amount, Your Honor. It's my understanding, and we can talk about this more if it helps later, but I think that the wrongful death suit has been brought by the mother of the children.
So he's getting 30 days that he has to sit. End of story. And the remaining 335 days are held over his head. And I am quite certain that if he violates in any way, Judge Washington will not hesitate to throw him in for the rest of his time. I don't think there'll be a second chance because this is his second chance.
And the restitution amount contemplates the funeral costs borne by Ms. McQuaid.
Gotcha.
Yes, that's my understanding. So I do think the restitution amount is not subsumed by this.
Yeah, I believe that's true, and the suit is not pending.
My understanding, we can talk about this.
I'm sorry, I didn't catch that, Ms. McQuaid. I'm sorry. Go ahead, say that again, please, if you have.
The restitution amount contemplates the funeral costs borne by Ms. McQuaid. Gotcha. Yes, that's my understanding. So I do think the restitution amount is not subsumed by this. I believe that's true, and the suit.
It's just the feedback from what the prosecutor was saying, so.
Is she listening through YouTube? So it may be delayed. If we can wait.
Excuse me? Can you hear me?
Yes, ma'am.
Hello?
Yes, ma'am.
Okay, the cost for the funeral was not included in Gabriella's lawsuit. That's why I asked for the restitution for the funeral cost, which was $5,500 for 3 hours.
All right, thank you so much.
Thank you.
Any additional $400-ish, Your Honor, come from the cost of printing the inputs, materials.
Restitution in the amount of $5,925.60. Fines and costs in this case for a total of $725. $30 per month probation oversight fee. You to report to the probation officer monthly via the online reporting platform and report to probation during the second week of each month. I'm gonna change that wording to make it read month, by the way. And report to probation when and where directed, including any and all home visits. You to complete the jail John Farms program while in custody. You to complete the ABR level 2 driver rehab course. You to complete the MAD victim impact panel within 45 days of release from custody. You to enroll in and complete the cognitive behavioral therapy program approved by this court within 14 days of sentencing or release from custody. So it'll be for release from custody. You'll follow all recommendations made and sign a release of information for the probation department. There's no use or possession of alcohol, marijuana, illegal drug paraphernalia, firearm components, ammunition, or other dangerous weapons, and no being in the presence of anyone carrying or using those. You will drug and alcohol test 1 time per month as ordered by the court, probation, or police. There'll be a review in front of me in 90 days. That's going to be on June 11th, 2026. And that'll be at 10 o'clock p.m. Would council approach, please? So, I called. Are we back on the record?
We are, Your
All right, we're back on the record. I called council up front to talk about, what it was going to look like in terms of a remand, because he is gonna be doing the 30 days. And, I'll let you make your arguments at this time on the record.
Yes, Your Honor, thank you. The people would request the defendant be remanded right now and start his 30-day sentence. I understand that he had health concerns. I understand he wants to make arrangements. DJ didn't get to make arrangements. DJ's family didn't get to make their arrangements. This happened to them all of a sudden. This happened to them in that moment. And I'm requesting the defendant be remanded right now. A jail sentence was always an outcome, potential outcome of this hearing. We set a special date for this hearing to have this time to have these impact statements and make these arguments. But we also, I think, if I recall correctly, had almost a month between the time of our last pretrial and now, if not more. Pull up my notes to double check, but yeah, 2-3. February the 3rd is when the defendant entered his plea at that time to set the sentencing date. So he's had the better part of 6 weeks to make any arrangements necessary.
Yeah, he knew jail was coming. For him to now want more time before turning himself in, that's ballsy. That is Metheny level ballsy. I cannot even believe that he's not just ready to go to jail. If he cared, if he gave 2 shits about what he did, he would be ready to go to jail right now and face his punishment. But no, he's going to sit up here and beg. I've got health problems still that I had at the last hearing that are unresolved and won't ever be resolved. But let me have time to get my affairs in order.
And the people would request that the sentence the court is imposing be imposed right now.
Thank you. Response?
Your Honor, I understand that he pled 6 weeks ago. we would ask that Your Honor give him at least till the end of day today or tomorrow. I did tell Your Honor and the prosecutor that there's a check that he's, anticipating to receive on Tuesday. He hasn't been working. He wants to be able to get everything situated before he goes to jail so that when he's out, he's able to start paying restitution immediately without having bills that are piling up, payments that are piling up, be able to get on probation immediately without, being started off at failure. So we'd ask that Your Honor at least give him till the end of the day today, or tomorrow to, talk to people he needs to talk to, take care of things that are going to be happening while he's in custody for the next month. If there's any medical things that he needs to take care of before he goes into custody. Is there anything else?
If I can have till Tuesday, I've been without any income since December 3rd when I had my heart surgery. Last day I worked was the 2nd, had heart surgery on the 3rd. I got a 4-day check. I haven't had no income, haven't been able to, I had to wait for unemployment. I got my first check last week. On the 4th, I get my next check, which will be the 18th. I call from unemployment Tuesday. If I can do that, then that way I can drop my phone off my home so I can have my niece take care of things for me while
So you can have what, sir?
so I can have my niece take care of things that need to be taken care of. But please be allowed to do that. Stating that I've walked this earth 51 years and I got a clean record. I will turn myself sin. If I can please just be allowed to.
I've heard arguments from both sides, and I appreciate them. Sir, I'm gonna remand you at this time. Go with the officers.
Step out here, please, Mr. Gray.
Yup. Good. Seeing him get cuffed and stuffed right in front of them.
You can call me from jail, Mr. Gray. Yeah, thank you.
The family needed that.
Thank you.
They're already getting shafted. The family's already getting shafted on how much time he's not getting because they couldn't make a stronger case against him, apparently. It's one of those things that pisses me off. It's like Lindsay. I've talked about Lindsay here before, my friend that got killed by a drunk driver. And the guy that hit him got probation. He got no drink probation. That was his punishment. Because he claimed that he hit Lindsay, didn't realize that he hit a person. And he went home and he drank a 6-pack after he got home. And then after drinking the 6-pack decided, I should really call the cops now. But he left Lindsay sit in that ditch for an hour and a half. And ultimately, that's what killed him, was the time that guy spent at home waiting to be sober enough to call 911. I know, I wasn't happy about it. I was not. I'm glad he got some jail time. But I'm just not happy about it. I know you saw Tiny Kitten's little entrance there. And now Billy's doing it too. Yeah. They've all decided that the new way to get up on my desk is to jump onto the back side of my chair. And sometimes using me for leverage, but it's okay. I've got tons of kitty claw marks all over my back. Mwah. Ha. I love you. Do you love your mama? Do you love your mama? Yes, you do. Oh, you are so jealous. Show the world how jealous you are. You jelly baby. You jelly baby. I can't even pet the cat. I can't even talk to the cat. You get all huffy over there. Oh, thanks. Did you see the newest one? We got Stitch or Snitch. Snitch, not Stitch. Snitch now. Yeah. Hold on. I posted Snitch in Discord. It felt appropriate because everybody in Discord watched Snitch enter my house like he owned the place. Yeah, so this is Snitch. Tiny Kitchen Esquire. Snitch. Tiny Kitchen. Snitch. Oh, yeah. Yeah, he just waltzed right in. Yeah. Well, I turned my camera on because I was going to show everybody my ramp. Because my handicap ramp, they're replacing part of it. They're not replacing the upper deck. They claim that that's, sound still. Yeah. It's not, but whatever. I'm not going to look a gift horse in the mouth. They're going to replace the worst part of it. If I fall through the main deck, I fall through the main deck. Then homeowner's insurance will kick in, I suppose. And they can cover the rest. Whatever. I'm over it. But but anyways, I turned my camera on to show everybody the deck the ramp, because as I walk on one side, it like makes sounds. And then when I turn around and I start walking back, you get about halfway and it goes ka-dunk. Because it's teeter-tottering. And if I stand in one spot on the bottom, and I can actually use it like Jeff Kiernan's bouncy ball. So I turn my camera on and I'm like, okay, you guys ready for this? And I open the door and in comes the cat. Just walked right. I'm like, that's not Tiny Kitten. You're not Tiny Kitten. Snitch, get back here. And I'm chasing him with my phone. I couldn't believe it. Just walked right into my house like he belonged here. So I guess he does. No. She does not like dogs. I know I've said that before. It's been proven. She does not like dogs. She's perfectly content being jealous of the cats. Oh no, she is jealous. No, the deck won't. It's the fall that will. I know. But remember, the deck's not actually in bad shape. It's just that the ramp is so bad that it makes the deck look like it's in bad shape. That's what the professionals say. I know. That was my argument too. Yeah. Yep. Best treats in town right here. I don't want to see Jeff talk about anything because every time I see Jeff talk about something, I imagine that he did a line of Adderall right before he started. So, yeah. So Monday I'll be calling the vet because I got chosen by the cat distribution system again. I don't remember putting an application in. In fact, I vehemently argued against another cat. There's a lady that works at Quick Trip that has 7. And that was my argument. I have 4. At least I'm not as bad as the lady at Quick Trip, and I'm getting there. They keep showing up on freezing nights. Oh, but I couldn't turn him away. We're getting 2 feet of snow. I can't leave him to freeze. It's the second blizzard he's come here for. And the first one, I let him be. He stayed out in Camp Coleman. And then he when I went out and I cleared a path for him, because he was just crying in the cooler, just crying his eyes out. And so I scooped snow away from the door of it for him to get out, and he bolted. And I don't know where he went. I think he was under the ramp, but that was another like 2-foot storm. And I was happy to see that he made it, the next time I saw him. But this time he's like, nope, I'm just coming in your house, lady. Oh my gosh. Your elderly dog absolutely appreciates it. Oh. Now he's inside, warm and safe, and a member of the PAWFURM. The lady from the pound that I was talking to, my pound girl, she was like, she said, you can name him Blizz after Blizzard since he came to you at a storm. And I'm like, no, he's a snitch. I have Bandit and I have Snitch and I have Tiny Kitten Esquire. Yep. Billy O.T., he is the head attorney, at the PAWFURM. Earl's the tech guy. We established that long ago. A new PAWTNER. But he's on the jailhouse side of things. See, Bandit and Snitch, they're the bad kitties. Earl and Billy O.T. and Tiny Kitten Esquire, they're the good ones. She was the youngest one of all of them. That was the thing that blew my mind. She was the youngest actress playing the oldest person. I loved it. I love the Golden Girls. I used to watch that religiously. I loved that show. Mama's Family, Golden Girls, Nanny. Oh, I loved the Nanny. Fran Drescher. Who could not love that voice? And then Married with Children, that was my fave. My favorite. I was a weird kid. I watched all old people shows. And I loved them. Oh. Yeah, that happened to us last week. It's begun. It's begun. I'm well aware of it. I just had to take Ava out and I came back in and I was covered in glorious Wisconsin sprinkles. I know, and she was the best. I love her. Oh, she was so intelligent in real life, and you have to be a very intelligent person to play a very dumb person. Like, and she did that so well. And she had some of the most amazing sound bites ever. Ever. The things that came out of that woman's mouth. Oh, she was a gem. Absolutely loved her. Oh, I remember that. I remember Mr. Belvedere. I did not. No, I didn't fall into that. I didn't do that. No. Murder, She Wrote, and Matlock. Those were not my thing. I don't even remember them. My parents weren't into them either. So I wasn't exposed to them. That's a fair point. I wasn't exposed to them. Maybe I would have liked them. I don't know. I never jumped on that train. I know they do. Yep. They don't like sardines, though. I bought a can of sardines, and I tried giving it to them. They do not like it. I don't blame them. I'm not a fan myself, but I thought fish, cats and fish. And they thought no. Oh, Bud was my first crush. He was my first TV crush. I had the biggest hots for Bud Bundy. I thought he was gorgeous, the little leprechaun that he is. TM show. And what? All the way back to the TM show. I'm confused. Confused. Confusorious. I don't doubt that a bit. I do not doubt that a bit. I remember I know one specific episode where they were getting pie in the middle of the night, sitting around the table, and they were going to eat pie or cake, one of the two. And Rose went off on some St. Olaf tangent, and apparently it was not a scripted tangent. They just got to a point where they're just like, let her go. Let her go. We know it's going to be good. Oh, I only saw that one a couple times. I enjoyed it. The black and white one, the originals, I saw those a few times, but not many. I did not see that. I did not see that one. Isn't that where that banjo-esque kind of music comes from? That as the cars like chase each other, and wasn't that Benny Hill? Cheesecake's my thing. They're my girls. Oh man, I love cheesecake. I don't get it often. I deliberately don't get it often. Because if I get it, I know I'm in for it. No to my Benny Hill impression that I'm not good. I'm not good. Oh, that is so cool. Eli's cheesecake is the best? Is that what you're saying? I I went a couple of years as Mimi for Halloween. The costume always went well. I have no idea what you're talking about, and I'm kind of scared to ask. That makes it worse. All right, guys. Thank you for coming and spending the night with me. Oh, I'm gonna try to get some sleep. I don't know how capable I will be of that, considering the new roommate in the house. Yeah. We'll see if he lets me sleep tonight. I'm gonna give him a can of canned food. Yeah, that'll keep him quiet for 5 minutes at least. At least. Wow. I was this close to meeting Rob Zombie. We crossed paths of a Hot Topic in Minnesota at the Mall of America. I'm so happy you were here, and I'm glad you had a good time. Oh no, it's too early to start testing Snitch. And Methany, she fell off the wagon, but she's back on it right now, right? Right? We gotta give them time for it to work out of their system before we start testing them. This is a rehab house, of course. PAWFURM rehab. Yeah, I just showed videos of him a minute ago. Where were you? We went in the Discord and I showed videos of him. Oh, I don't doubt that a bit. I don't doubt that a bit. My daughter met Michael Rucker. She was at Comic-Con when she was like 7, and he saw her walking through the crowd with her dad, and he actually stopped everybody because he wanted to meet my daughter. And the funniest thing is that's not the first time that has happened. I mean, she really is an absolute force of nature, and she always has been just this charged energy and just draws people to her. But he seriously stopped his booth at Comic-Con and demanded a picture with my daughter. I have it too. It was on my ex-husband's grainy cell phone Back before digital cameras actually mattered on a phone. But oh, such a good picture. He's such a nice man too. He's so funny. No, Earl does not approve. Earl vehemently does not approve yet. Actually, I think it's very similar to the Bandit situation, where Earl approves to the point of wanting to sniff the butt, and the other cats don't want the sniffing of the butt. So when Earl attempts, they lash out at Earl because they think he's, gonna bite their ass or something. I don't know. So they lash out at Earl, and then Earl lashes back. That's how it always goes. I think Earl wants to approve. He just wants some mighty fine cat butt sniffins. I swear that cat, his favorite thing to do is sniff ass. And every time he comes up on the desk, he puts his butt right here as if that's my favorite thing to do. And it's not. It's definitely not. I know, but I am not as thrilled about butt sniffing as Earl is. It's just not my thing. It's possible. I mean, no, because Earl actually lets Ava hump him. So, I mean, closet maybe. Man, my cats are weird. Oh, I know. Which also makes me wonder, like, how long do they keep the familial marking scent? Like, if that is Tiny Kitten's daddy, does Tiny Kitten's butt smell like Tiny Kitten's daddy's butt? Like, because they're from the same family? Is Earl going to be able to recognize that? Is Earl going to sniff both butts and be like, that's a match? That's a pair. They go together. The closest I get to that is I will not do any drug that had to be carried up somebody's ass to get to me. If the drug had to go through the anal portal to reach me, I don't want it. It can go back where it came from. You already knew what you were after. Oh, you guys are great. I love you all so much. Thank you for being here. Be safe, be well, sleep sweet, and much love.